happens. They were talking about the Romal power, retention of title, clause, which is one of the things that is touched on here. It's not crucial that you discuss that in the assessment, but if you do, it's capable of elevating your performance. But don't go into too much detail. But it just shows that you really understand what we're on about. So if I can't see any comments from you, I'll just proceed to talk about passing of property and risk. So the CRA defers to the SGA for the point at which property passes. This is not something the CRA addresses, and it also does not deal with the NEMO that we just talked about. But when it comes to remedies, you have to go to the CRA because the consumers has more protection when it comes to remedies. Yeah. So the relevant sections of the SGA is 16 to 20B. In relation to the passing of risk, the CRA is very clear on when risk passes to the buyer. According to the CRA, if the buyer is a consumer, risk does not pass to them until the goods have been delivered. So the time of the contract will be at one time. It is not until they get delivery, physical delivery of the goods, that risk passes to them. There is the exception of when they've allocated a carrier, they've appointed a carrier, the consumer. In that case, risk will pass to them. But let's get started. Again, if you're faced with a question on passing of property and risk, and this is a favorite among students going by past experience in the previous years, students really like this topic. I think they do well as well. So, and it's always a problem question. A contract of sale, you want to define that as a contract where there's been a transfer or an agreement to transfer property and goods for the consideration of money called price. So it had all those elements: transfer, property and goods, consideration called price. Those are the three main elements. So what is the meaning of property? And this is a question to all of you. What do you understand by the meaning of property? What does it mean? Is there any other words we can use to... Okay. Think someone. Ownership. Very good. So property means ownership, the right, and the highest level, the way you exercise your property is the ability to dispose of the property, of the goods. So that's the highest level through which you can exercise your right to property, the ability to give that to someone else, to sell it to someone else. And why is it important? Why is it important to know who has property? Okay, good. Let's see. General property. Okay, good. Yeah, general property. Good. In goods. So if the party in possession sells the goods before ownership passes to them, then the owner does not take title. And then we go back to the name with that principle. We go back to section 12. There's been a breach of a condition, etc., etc., etc. So one thing we would have realized based on what we talked about in your previous lectures and in this revision lectures as well is possession does not equal ownership. You can possess something. I possess this computer. It doesn't belong to me. It belongs to the MMU. So you can possess a car through conditional contract. That doesn't mean you own it. So for commercial settings, possessing something, being in possession of something doesn't mean you own it. So possession does not always equal ownership. That's one of the fundamental rules. Now, when we're talking about why is it important, it is important for lots of reasons. So if we know who has property, we know who has risk. If we know who has property, we know who has an insurable interest in the thing. So if it's yours, you have an insurable interest in it. There are some exceptions. You can be in possession of something that is not yours, like maybe a car, on hire purchase or conditional sale. You can still insure, but who is going to bear the loss when that thing becomes destroyed? So what if you buy from someone who goes into liquidation? Remember in the question we just treated, Edwina doesn't have any money. So if possession, if she declares bankrupt, that becomes it becomes a problem. So yeah, what if you sell to someone that goes into liquidation? What if you buy from someone that goes into liquidation? So when property has passed, you as a seller cannot sell this item again. You can only sue for non-payment or for the price if property has passed. If property has passed also, the buyer can sue for non-delivery. So looking at what section 649 says, it provides that where the property has passed to the buyer and he wrongfully neglects or refuses to pay for the goods, the seller may maintain an action against him for the price. That doesn't mean the seller can resell the goods. We see what that happened in the previous case. Although we need to know that it is possible to say in the agreement that payment can be for a later time. So property can pass before payment has been made. It's a very complicated topic. Now, still talking about why it's important, unless otherwise agreed, this is the provision. The goods remain at the risk of the seller until property passes therein to the buyer. But when the property in them is transferred to the buyer, we always say risk follows property. Risk follows property, except in consumer contracts. So you see that there. There's yeah, happy to see that it's there in section 29. And know that you can divide title and risk. It can be divisible, but this is a general rule. So delivery generally means actual delivery to the buyer. Still moving on with that line of thought. Property can pass at different points, but this will be determined by the intention of the parties. And we can also look to the act to identify what the intentions are. You might want to buy goods, but not want them delivered immediately. In fact, that's the way the commercial sector works. You want to buy goods now, but you don't want to take delivery because you don't have where to put them. Just think about those people selling with Amazon. So they can buy goods, put it with Amazon, put it with Taobao, and then keep selling it. They don't even take delivery, actual delivery. So they just keep it there and sell it on. So you might want to buy something you don't want delivered immediately. Um, for example, someone buys a mobile phone that is damaged after the contract but before delivery. The question you want to ask is who bears the risk of that damage? Is it the buyer or the seller? The answer to that would depend on whether the person is a consumer or a business. If it's a business, we follow the sections 16 to 20 of the SGA. If it's a consumer, you cannot get property until it's delivered. I think that's section 29, if I remember correctly, of the CRA. So now, title and risk. If passing of property and risk are separate, but we know that when it comes to commercial transactions between B2B contracts, risk follows property. But in the assessment, please talk about this separately. Don't assume that because you've discussed property, you don't have to talk about risk. Because this is a common mistake students make. They assume that because risk follows property, they don't have to talk about it. Even if it's a paragraph at the end of your analysis on the passing of property, make sure you also talk about risk, because if you do not do that, you will miss points for that. So, and you're going to see if the answer makes it clear. In the first one here, it just says advise the parties. But when we say advise the parties, you still have to talk about risk, because the whole discussion about property is because you want to know who bears the risk anyway. So don't forget to talk about risk in your analysis, in the assessment. Right. So now, why do we need rules on title and risk? I mean, we said that before. We want to know who owns the property, because it's the person that owns it that is able to sell it off, that is able to lay claim to it, and it could also help us determine who bears the risk of loss on damage. So what are the rules? Section 16 to 20, and this is where it becomes interesting. I must confess, I always enjoy reading your answers on this because it shows your high level analysis. I mean, talking about the previous set, I know you're also up to the task because it just shows your high level ability to analyze and break things down, apply the law to the facts using authorities, your sections, as well as some cases. So we have different rules on when property and risk, when property pass. These would depend on if the goods are specific or unascertained. And when we talked about this on Monday, one of you pointed it out that I think we're talking about specific and unascertained in relation to what was that? Can't remember. Was it? Yeah, we're talking about this on Mondays. Lots have happened since then, and some of you were really ahead of the game. We're talking about this. So title in goods cannot pass until they've been identified to the contract. So we know easily with specific goods, title passes at the time of the contract. But with unascertained, the goods have to be ascertained first by the seller with the assent of the buyer or by the buyer with the assent of the seller before they can be allocated to the contract. So this is the overview. If you're looking for a cheat sheet, this is it. So for specific goods, we look for the intention of the parties. If no contract intention applies, you follow section 18 rules 1 to 4. For unascertained goods, section 1 says you cannot transfer, property cannot transfer until the goods become ascertained. Then the second stage is section 17 say once ascertained, look for contractual intention. If you can't find any contractual intention, go on to talk about the rule 5 of section 18. So let's start. I want you to pop in the chat what you think specific goods are. So that television there, those 4 tomatoes, the one in the window. So these are goods that have been identified. That's the first step. They've been identified, pointed at, and agreed upon by both parties at the time of the sale. So what other examples can you give us of specific goods aside from these on the slide? That television there, those 4 tomatoes, that one in the window. Any ideas in the comments? Oh, I think we got to okay. Let's see. Bottles of wine I have in my storage. Yeah. Maybe yes, but you want to say iPhone. iPhone is generic. Will shook. You might want to say my iPhone with the pink case, or my iPhone with the purple case, or my computer that I'm currently using. Yes, bottles of wine I have in my storage. That doesn't. You want to say maybe all my 10 bottles of wine, the one I selected. Yes, that pen I selected. A desktop computer with that. Yes, not A. You won't say A. You say that desktop's computer with this serial number. Because serial number is allocated to, we're going to see how this is very easy to identify what a specific good is. And I want to assure you that a vast majority of students, if I'm reading maybe 100 scripts, maybe 200 scripts, maybe one person would get it wrong. Do you get the point? So for specific goods, it's very, very straightforward. Many students get it right. And if I wanted you to look at the pattern of what we answer in relation to this question, and you'll be able to get a feel of very good. The gold coin I bought using my broker. Yes. If there's just one broke coin. So remember, you must specifically identify. The identity must not be in doubt. Identified and agreed upon. So if you're saying a car with a specific registration number and license number, so you can say my car with this specific with this registration number. So I don't want us to sweat it. We're going to understand what this is all about. So when it comes to the sale of specific goods, The property passes at the time the parties intend, and regard should be had to the contract conduct of the parties and the circumstance of the case. So, how do we know what the intention of the parties are? The Lord Diplock was the view that it should pass on delivery or payment, but other cases have held that we should look at rules 1 to 4 of section 18 to understand how that is. So let's start looking at that. And you will have to do that. You have to apply these rules. I don't want to give you certain way of answering it, but you will. It's easy. Lots of students get the first two right. So you're going to apply to the contract for the sale of specific goods where the intention was not of the parties not expressed and cannot be inferred. So when we're not clear about what the parties have agreed on, we'll go to this. The first one says, in the sale of specific goods, that is unconditional. There are no conditions to be performed. There is nothing, no condition attached to the contract. Title passes at the time of the contract. So if the goods are in deliverable state, the property passes to the buyer when that contract is made, and it doesn't matter if the time of payment or delivery are postponed. Remember, we're talking about B2B contracts here. It's very much straightforward when it comes to consumer. So delivery state was defined in section 61(5) as a state where the buyer is bound to take delivery of the item. And we've got some cases there. We've got Underwood and Berg Castle, where the item was screwed to the floor. So unconditional, Valley versus Weeb, Denant and Skinner. If it's a conditional sale, a common example might be where the seller reserves the passing of title until payment. So this could go contrary to that. But that is a condition, isn't it? So if he decides the passing of title, that is a conditional contract. Rule 1 doesn't apply. So in section 19(1), it provides that when there's a contract for the sale of specific goods, or where the goods are subsequently appropriated or allocated to the contract, the seller may reserve the right of disposal until certain conditions are fulfilled. And in such case, title will not pass until that condition has been fulfilled. So if it's a conditional contract, rule 1 does not apply. If it's unconditional, title passes at the time of the contract. And also rule 2 says when the goods are not in a deliverable state, that's what it's saying here. When the seller is a specific good, right? But the seller is bound to do something to the goods for the purpose of putting them in a deliverable state, property will not pass until that thing has been done and the buyer has noticed. So this is a two-pronged test. If it's not in a deliverable state, first it has to be put in that state, and the buyer must have noticed that this thing has been done. In some answers, I've seen students interpret this rule, apply it really well, but then they don't talk about the notice part of it. And you will lose points for not doing that. So remember, talk about the notice. There has to be notice by the buyer that that thing had been done. So that's it for specific goods. Deliverable state, undeliverable state, unconditional, conditional contract. Now let's move on to talk about uncertain goods. And this is where the bulk of your analysis will go into. Uncertain goods. These are goods that are identified only by description. And looking at the examples you've given, let's see if let's look at a car with a blue a 2004 model car, a 2024 model car. Is uncertain. So any car that was produced in 2004 would do. So these are really goods that are not. Yeah, I think I'm. So these are goods that are not identified or agreed upon at the time of at the time of sale. These are goods defined only by description, depending for their identification. If identification needs to happen after the contract. So one of those pitches a car like the one in the brochure. Order me that hi-fi magazine. Order me in a what hi-fi. Grow me some potatoes, a Hitachi widescreen TV, an iPhone computer, a no an iPhone, a an Apple computer. Those are uncertain. So anything matching that product will do. And we're going to see the sense in distinguishing between specific and uncertain goods. I think the definition has been that uh, goods that are not specific will more likely be uncertain. So section 16 provides that in the sale of uncertain goods, there cannot be passing of property unless the goods become ascertained. Because how can you say, oh, yeah, an iPhone, and say property has passed in an iPhone to you without you identifying the iPhone that is subject to the contract? So goods need to be identified and agreed upon by the parties afterwards. So that would be ascertainment. But when it becomes ascertained, then that's when we can talk about passing of property. And the court in Rewage said goods are ascertained when they are identified per the terms of the agreement. So when they are ascertained, no property will pass until the parties intending to pass. And that's why we have to look at section 18 rule 5 and determine what the intention are if that's not apparent in the contract. And in many of the questions that have been examined in the past, you often have to interpret based on the rules. You have to interpret based on the rules because the intention is not always apparent. So what does section 18 rule 5 provide for? It says that where there is a contract for the sale of uncertain or future goods by description, and the goods of that description in a deliverable state are unconditionally appropriated to the contract by the seller with the assent. Yeah. So let's look at the keywords here. In the sale of a contract, uncertain or future goods. So that's a keyword. There has to be unconditional appropriation, and we will see how courts have interpreted this provision in the questions we're going to be looking at. So what is unconditional appropriation? It is only when that has been done by the seller with the assent. So the buyer has agreed, or the buyer with the assent. So assent might be presumed, it could be expressed or implied, but it has to be present anyway. So now talking about what we consider as unconditional appropriation. The first is it has to be that thing that has been done by the seller that there is no return from. So if there is a store that you said, oh, give me, yeah, let's talk about your example, the wine in your, yeah, let's look at the wine example. The wine, bottles of wine in my storage. So I'd like to buy one of the wines in your bottle of wine storage. Yeah. Wine, one of the wine bottles in your storage. So when does appropriation happen? Is it when you take a sticky note and write sold to Lee or I mean sold to Wong? No, because you can still go back and drink that wine. Nothing stops you from doing that. So it's a bit tricky determining when it's been unconditionally appropriated. So this is what the court said in Carlos Federspiel essay. This is a very good case to remember, guys, but don't worry if you can't. You can use any of the other ones as well. For Carlos, it's a really good case in terms of this because the court says that setting us aside or selecting by the seller of the goods he wants to use is not enough. If that's all, he can change his mind and use those goods in performance of another contract. Now, talking about the serial numbers you've talked about, you mentioned earlier in the comments. So if it's regarding a mobile phone or a computer and you've sent the serial number to the buyer, that means you cannot, it has become unconditionally appropriated, because sending it to the buyer means you cannot turn back. But if you don't send it to the buyer, you can still sell the computer to someone else. And if you're a business person, well, I've done business in the past. My mom really was a business person. What they would do is, oh, maybe someone has agreed to buy something, and they said, oh, I'm selling this one in the warehouse. I'm selling this to that person. And you see someone coming to you with a higher price, and you're like, yeah, I'll sell this in the warehouse now and I'll get other one. So that's what the court is saying in Carlos Federspiel, that setting it aside apart is not enough. More has to be done. So you got other authorities, which is providing of serial numbers. That would be good if you provided it to the buyer and they've agreed that you cannot, if anything happens, property has passed. So what it means is that in effect the goods must no longer be under the control of the seller. That's when we can say that's unconditional appropriation. So inconsistencies have been seen in the case of Re London Wine and Co and Re Ellis. We're going to see that too in answering the question, so I don't want to dwell on it now. The goods must be in a deliverable state. That's also another element of that rule. It has to be in a deliverable state. If it's not in a deliverable state, you cannot make an unconditional appropriation. And it has to be with the assent of the buyer or vice versa. So who is making the appropriation? It has to be with the assent of the other party. So if the appropriation is being made by the seller, it has to be with the assent of the buyer. And if it's being made by the buyer, it has to be with the assent of the seller. I think it goes, there's a very good example of this. When we go to the store and we're picking up items where we're still not owning those items until we've paid for them and they've been set aside. Or maybe you're buying something on a Taobao. You can't say property has passed. If you're buying as a business, that is, you cannot say property has passed just because they've moved it to one side. Like I said, they could always change their mind. Now, if this is delivery in relation to delivery by a third party, Section 5, Rule 2 provides that the seller delivers the goods to the buyer or to a carrier and does not reserve the right of disposal, it will be assumed to have unconditionally appropriated the goods. Because you can't, if it's a third party that is not within his control, if it's being delivered by he himself, he can still change his mind, like my mom, and drive it to someone else's place because they're paying the higher price and you can always get other goods to satisfy your buyer. But if it's a third party, you can't call them back and say you want to get the item. So that would be deemed to be a unconditional appropriation. So Section 5, Rule 3 talks about appropriation by exhaustion. And that could go to the wine you talked about in your cellar, in your fridge. If there were 5 wines there and you said the wine in my fridge, one of the wines in my fridge, and you've taken 4 of them, we would assume that the last one belongs now, property passes to the buyer. So where there is a contract for the sale of a specific quantity of uncertain goods that are all in a deliverable state, when that bulk reduces to less to the quantity that the buyer wants to buy, then we can say the remaining goods are to be taken as appropriated to the contract. And we would then argue that the property in those goods will pass to the buyer. So I don't know. There's someone typing something in there. I think is that a mistake or something? So if only your goods are left in the bulk, it is automatically appropriated. If you have more than one order, even that adds up to that, we would say that has been unconditionally appropriated. So passing up property in part of a specified bulk. So if you say that's a specific bulk we're talking about, then Section 20A is a relevant principle. It talks about undivided shares in goods forming part of a specified bulk. So we've got some illustrations of what this could look like in reality. So if the bulk is identified in the contract or subsequently, and at least some of the goods are paid for. So remember with the other ones, you don't need to have paid for the goods. But when we're talking about passing of property in a specified bulk, in part of it needs to be have been paid for, and the buyer becomes an owner in common with other ones. And this is a tricky one, but it's easy to understand. So in this example, buyer buys 100 oranges from a pile of 1,000. If he has paid for them, then he owns 10% of that 1,000 oranges. So if the seller sells 900 oranges, the remainder, the 100, will be deemed to have been unconditionally appropriated to the contract. So this is an illustration of that. Orange 1,000 oranges in stock, retained by seller 900, and the buyer has 100 of it. So if the seller sells 500 of the bulk and delivers them, then it will leave be with 20% of the remaining 500. He has a certain interest in 100 of anything that is left. So in this case, that seller sells and delivers 500 of the 1,000. So there is only 500 left. What that means is that the seller has 80% of the bulk, which is 400, and the buyer B has 100%, which is 20%, 100, which is 20% of the bulk. If you're buying as a part of the bulk, and the seller has unsold goods in the bulk, and they are if these are destroyed, so let's go back to the previous slide. So if out of the 500 remaining oranges here, 300 are destroyed, then we know we have 200 oranges left. The assumption would be that the seller now has 50% of the remainder and the buyer has 50%. Nothing is happening to the balance that is owned by the buyer. Another scenario, if 400 are destroyed, we would assume that the seller has no oranges left and the 100 that is not destroyed belongs to buyer B. Yeah, I think this is so. What if 500 were destroyed and 300 remaining were what if 300 of remaining 500? What if 450 of remaining bulk of 500 is this of what if he sold 450 of the remaining bulk to C? He has infringed on the interest of buyer B because he has sold the goods belonging to buyer B. So buyer B now has to sue him for non-delivery. So let's look at a situation that doesn't involve the seller, but involves the buyer and other buyers. So we have buyer B that buys 200 and buyer C buys 300 of the 500. What will happen if there is a partial destruction of that 500? So say out of the total, we know 20% belongs to one, 30% belongs to one, 200, 300. If the bulk is reduced to less than the owner's amount, then all owners will take a proportionate reduction. So assuming that 100 tons is destroyed, it will be shared in the same proportion of ownership amongst the buyers. So buyer B will lose 40% of their, because they own 40% of the balance anyway, and buyer C will lose 60%. So they will lose 40, 60 respectively. We're going to see how that plays out in this scenario because I think this is one of the things that is examined in the revision question. This is the part I said you should not forget to talk about when you're answering the question. You want to refer to property usually follows, risk usually follows property, and that's what section 21 provides. Remember, you can agree otherwise, but if you do not, the goods remain at the seller's risk until property is transferred to the buyer. But when the property in them is transferred, then the risk will be transferred as well, whether delivery has been made or not. But there are limitations which can be found in subsection 2. If there has been a delay that is the fault of one of the parties, it is the party that caused the delay that will be affected, that will be responsible for that. Custodian must also take reasonable care if they don't want to be liable. But remember what I said, Section 29 of the CRA says a buyer does not, risk does not pass to the buyer until it's been delivered. So that's straightforward when we're talking about consumers. This is the provision of the Act. Uh, yeah, so I think that was, yeah. So, so those are the provisions of the Act, and then we'll move on to the next one. So impossibility. You can listen to that. It was recorded by someone else in the past. Did you hear? Do we need to mention CRA? I don't think you need to if it's a B2B contract. Do you understand? Do you understand? Yeah. If it's a B2B contract, you're just seeing this as if you can if there is a consumer in the scenario you've been given, then you want to apply Section 29. It's straightforward. If there is a carrier appointed by the consumer, then of course property would have passed to them. But if not, property will not pass until they've got physical delivery. Now, higher level, top level answers deal with this. This is one of the ways students distinguish themselves by talking about, yeah, is that a question there? Do we need to, does the seller absorb destruction approach applies to both B2B and B2C contract? That's a very interesting one. But remember that risk does not pass to the consumer anyway, Huey. So, ownership in the bulk, risk does not pass until the consumer gets actual delivery, right? So even if property passes to them, risk does not pass. Yeah. So top level answer will deal with this. Talk about frustration. Section 6 and 7 really deal with the common law principle of frustration. So if there's a contract for the sale of a specific goods and that goods does not exist at the time of the contract, that contract is void. So default lies where it falls. If it's a contract for an illegal item, some you're trying to buy a gun when it's illegal to buy a gun, the contract is void. Um, you cannot sue for delivery. No, you cannot sue anyone. And the authority for that is Katuri versus ST, where Katuri, where the goods of the corn are deteriorated by the time of the contract, the court said, yeah, that's frustrated. The contract, no property pass is void. Yeah. And section 7 as well. This talks about if after the first one, section 6 is about before. Section 7 is if after the contract there is a destruction, there is a frustration of the contract because the goods no longer exist, then if this is not because of the fault of either of the parties, then the agreement can be avoided. And you can see the sense in this. In the first one, section 6, the parties are agreeing on a contract that does not exist, or on goods that do not exist. How can you sue for non-delivery of goods that do not exist? It can never be delivered in any way. And in this case, if you're talking about, okay, yeah, we've made a contract, but it becomes destroyed as a result of something else, not because we've done something wrong, each of the parties, then you cannot sue for delivery because it's a specific good. Is that pink iPhone? Is the wine in my fridge? It's just one wine. It's specific. So this is a sense in it, and it goes to the topic on frustration of contracts in contract law. So high level questions, answers rather, talk about those in the assessment. So I want to quickly say if we can finish one question before we draw the curtains for today. So that means on Monday we'll be talking just about exemption clauses. I mean, answering the second question, we'll talk about exemption clauses, answer questions on those as well, and then you'll be, yeah, void and avoided. So avoided means give notice that you want to get out of the contract. So that's you. This is the same way you avoid a voidable contract. It's the nuance. It's the same way you avoid a voidable contract. So you don't need to pay any remedies whatsoever, providing you can prove that it is due to no fault of either parties. If it's due to one of the parties' fault, then of course you may be able to claim damages for that. So the distinction between the two is one is before the contract is entered into, and the other is in relation to after the contract has been entered into. So let's look at this question: transfer of property and risk. I want you to put in the chat the main issues you've been able to discover. It would be really great if you can identify the relevant provision in your chat so I can see that you really have a good grasp of this. I don't want it to be all one-sided. And if you've noticed, since we started, my approach has been to um, get you to engage, get you to talk about this, just so we're sure that we are all getting it right. So pop in the chat the main issues you've observed in the question, and also you may want to comment on the relevant sections of the act. Yeah, so I can see that the comments are coming in. Keep it up. Yeah. So the starting point, yeah. So let's see what you said. On Monday, I'm going to tell you again the same thing I've said about it. So rest assured about that. So it goes, you need to talk about the types of goods. Um, so the part, notice, I don't think that's what the Act provides for. I don't think that's what the Act says in relation to avoiding that contract. You just have to look at the provision of the Act, and you look at the provision of the Act and see what it says in relation to that. Remember, the Act is the primary document you want to refer to. So you're saying B2B and mixing the questions, so the buyer must give notice to, okay. Yeah, so I want to see more comments on this. The starting point is to identify the main topic. This is in relation to the passing of property and risk in goods, and you want to reiterate the importance of determining when property in goods passes, as this is often the point where risk passes in business to business transactions. The situation could be different for business to consumer transaction. So you're saying 10 for his business and 1 for his daughter. Okay, so that's a very good point. Hung, what all in favor of this being a B2B contract that is governed by the SGA or a B2C contract? Can we put that in the chat? Because it's a mixed contract, isn't it? The intention of the parties, yeah, that has to be. So you're saying 10, he bought 10 for the and 1 for the birthday of his daughter. Is it this question? Adam agreed 10 for his business, 1 for his daughter. Ben agreed to buy. Yeah, yeah. So even if it's the we're going to say this is wholly for a business sake, and we're going to proceed with our discussion. But even at that, the CRA does not deal with the issue of passing of property. So the bulk of your discussion will be the SGA anyway. So if you, peradventure, you think the CRA is relevant, then it will be on the passing of risk. CRA consumer, there's no such thing in CRA consumer contract. I don't understand intention. CRA consumer, is that meant to? Okay, so let's move on and talk about this. I know we're all tired. I can see that emoji. So 25 more minutes to go. We'll be done. Don't worry, guys. So we're saying the CRA does not deal with passing of property and risk, except in the case of passing of risk in the B2C contract. That's relevant. So pursuant to Section 20, unless otherwise agreed, the property remain at the seller's risk on property in them as passed. We know what that provision is. But going by the CRA Section 29, where the buyer deals as a consumer, then this rule is displaced, and the property risk will be with the seller until the buyer has physical delivery. So the rules which apply depend on whether the goods are specific or uncertain goods. The main point in this case is that it is wholly for a business. So he's buying 10 things, isn't he? And those 10 things could either be, those 10 things are a B2B contract, and then one of them is is for a consumer. So it is wholly for the purpose of the business. So we're going to apply the SGA to this. So going to the issue of whether these are the rules that apply, you want to talk about this will depend on whether the goods are specific or unascertained. We see that he bought 11 computers, 10 for his business and one for his daughter's birthday. And he has had the model demonstrated to him in the shop. So that means these are uncertain goods because they have not been identified with and agreed upon at the time of the contract. They've not been identified and agreed upon at the time of the contract. So the contract is for any 11 computers fitting the models. The goods are identified only by their description, and later they need to be ascertained before they can be assented to. Say that types of goods makes no difference in the context of the CRA. So when it comes to, oh, you're saying whether it's specific or unascertained, on what basis would you say that? On what basis? Because it's the reason we're discussing ascertained specific is to determine the passing of property. The only thing commented on by the CRA is the passing of risk in a B2C contract, passing of risk. So we would have talked about passing of property anyway, and that's governed by the SGA. Oh yeah, so it doesn't matter. It doesn't matter anyway. You know, with the SGA, risk follows property. With a consumer, risk doesn't move until it gets to the buyer. Is get delivery. So I don't think that's a discussion you want to explore. It's not necessary because the CRA does not discuss the issue of passing of property anyway. So you still have to go through the motion with the SGA before talking about risk and applying the SGA. Yeah, with the CRA, sorry. So moving on. Any computer, these are unascertained goods. So you want to ask, how do we determine when property passes in unascertained goods? Section 16 says that in the contract for a sale of unascertained goods, property will not pass until the goods have been ascertained. And when they've been ascertained, we have to look at what the parties agreed to. And the authority for that is reweight. The goods here have not been ascertained at no point because the goods have been identified. This means that the property in the goods has not passed from SIA to Adam. So the risk will therefore remain with SIA, and Adam will be entitled to sue for non-delivery if SIA cannot provide replacements for the goods within the specified period of time. And the reason he's able to sue for that is because these are unascertained goods. So there is no question of frustration arising because SIA can source them again. So if you were to be specific goods, then we can talk about sections 6 and 7, but because it's unascertained, then there cannot be any issue of frustration. So that's the thing with the 11 laptops. Now, in relation to relation to Ben, he has agreed to buy 5 personal organizers like the ones on display. So again, he's describing the item. So 3 were for employees of his business and 1 each for himself and his wife. So these again appear to be unascertained goods because he looked at a display model and ordered 5 new ones. So the shop can supply any 5 new personal organizers under the contract. The goods are only ascertained once they are identified in accordance with the contract. Notice here that it doesn't appear to be so from the question, but if Ben and Sia sales represent the sales representative agree at the time of the contract that there are only 3 remaining in the warehouse and no more, and that Ben will be given those 3 remaining from the warehouse. It will be a contract for specific goods. And that's the example you gave earlier when you were talking about the wine in your fridge. So if it's just 1 wine, then we know that's specific. So if we have just 3 from the warehouse, then those 3 will be determined to be ascertained. So the wording of the question suggests that the manager only has the warehouse staff to remove the warehouse stock after the contract is entered into. So this would appear to be unascertained goods because it wasn't agreed and identified at the time of the contract. So the rest of the answer will proceed based on this. So the shop manager here has asked the warehouse man to take 3 personal organizers from the warehouse and leave them in the dispatch area to delivery to Ben, and also ordered a further 2 from the main source supplier in Japan. So now we need to determine whether this amounts to unconditional appropriation or ascertainment in accordance with the contract. Even when ascertained, no property will pass to the buyer until the parties intend them to pass. And if there is no intention clear from this, then we have to apply Section 18, Rule 5, which provides that in a contract for the sale of unascertained goods, future goods by description, and goods of that description are in a deliverable state, and they are unconditionally appropriated, that is when property may pass. But look at this case. There are 2 main elements. They have to be unconditionally appropriated, and this will need to be done with the assent of the other party. Remember the 2 cases we talked about, the Carlos Pederspiel and Charles Twig, where the court said that goods are appropriated to the contract when the parties had an intention to irrevocably attach that to the contract. It was noted in that case that merely setting aside or setting apart the selection by the seller is not enough. And if you think about the example I gave you, you can always sell that on and get other goods to satisfy the contract. The buyer would not know, would they? So if that is all, he could always change his mind and use that contract otherwise. And if you write the names of the customer on the goods, you can always remove that and still sell the goods. So moving on to talk about the case of Re London Wine Co., a wine merchant who set aside a box of 12 bottles of wine in the warehouse to fulfill a contract, was held to not have irrevocably appropriated those things to the contract. And he also did not do that when he put it in the van for delivery or when he writes the name on the delivery label. The court said he had done nothing that he can't change his mind about. So that shows the extreme how we construe unconditionally appropriated. And it would seem here that the SIA has not done anything irrevocable to appropriate the goods to the contract. So this would not be the case if the order had been identified, and yeah, the personal organizers can be used in the contract. We could look at the case of Hendy Lennox and Graham Potix Engine, where the seller sent an invoice showing the serial numbers uh, of the engines to be delivered. And it was in that case the court said the goods were indeed unconditionally appropriated, because if they are delivered, the buyer could all look at the serial numbers and say, you know what, this is not what you sent to me. These are not my goods. So property would have passed in that case. So here, it would seem that none of the five items had been appropriated to the contract, so the property and the goods have not passed to the buyer, and therefore the risk will remain with the seller. This also applies to the ones ordered from abroad, because you could use that for other purposes as well. Like I said, business people do this all the time. So Ben, in this case, could sue for non-delivery of the goods if they are not delivered by the time stipulated in the contract. So again, we cannot apply the doctrine of frustration here, because the goods are uncertain. They can be sourced elsewhere. They're not specific goods. So moving on to talk about Claire. She agreed to buy the CRX demonstration model for her business. So SIA went to install all the necessary software on the computer before delivery. So this is a specific good that requires something to be done to put it in a deliverable state. So you can think about the relevant principle that applies here. So we want to start by talking about Section 17, which applies to passing of property in specific goods. Section 17, you can talk about the provision, which is to the effect that the property in specific goods pass when the parties want them to pass. And Section 17.2 said we should have regard to the contract, the conduct of the parties, and the circumstances of the case. You can look at the authority of Ward, W-A-R-D, and Bignall, in which Lord Diplock said, in modern times, very little is needed to give rise. That quotation is in the slide. Here, in this case, delivery and payment are separate rather. So it may be difficult to find intention from that. But if no intention can be inferred, we have to refer to Section 18 that lays down the four rules 1 to 4, that will help to guide us on what the intention of the parties may be. So rules 3 and 4 are not relevant, because do you have to differentiate between B to C contract? For the purpose of passing of property, no, because even in a B to C contract, the CRA does not say anything. We've said that before, but it only talks about passing of risk. In the first issue, it's just one laptop. In the grand scheme of things, compared to the other 10, yeah. And we said in the first one as well, it wasn't appropriated, so we don't even have to talk about risk. Frustration cannot be applied to questions A and B on the work. Yep. So I can talk about that. I hope I'm still able to run through this. So frustration, the way the doctrine of frustration works is that frustration is when it is impossible. It is not when it's difficult, no. When it is impossible for the contract to go ahead. So if you've entered into a contract for the sale of your Chevrolet, which I'm selling my Chevrolet to you, It is just one Chevrolet. It is specific good. So if that car has been burnt at the time of the contract, it is impossible to deliver it. Do you understand? So frustration is only possible for specific goods. But when it comes to unascertained, if property has not passed as a seller, the argument is it may be difficult for you to order for the same for similar goods. It may take time, but a contract is a contract. You can always source for those items elsewhere. It is not impossible to complete the contract. Do you get my point? So frustration is possible going by section 6 and 7 and the common law is only when it is impossible. And when it is specific good, it is impossible. But if it is unascertained, a 2024 model car, if the model you think you want to sell has been destroyed, you can always source for other ones to sell. Do you understand? So it would be a burden on the seller, yes, but is still able to get it. But compared with specific goods, it's practically impossible to get that good because it is specific. So I'll continue. Rules 3 and 4 are not relevant because they relate to measurement, weighing, and all and etc. So we're going to focus on rules 1 and 2. Under Section 18, Rule 1, when there's a contract for the sale of a specific goods and it's in the deliverable state, property passes at the time of the contract, and it doesn't matter that but payment and delivery or both are postponed. In relation to Rule 2, when there's a contract of sale in a specific of specific goods and something needs to be done to put them in a deliverable state, property doesn't pass until that thing has been done and the buyer has notice. So we want to ask ourselves, what's the meaning of specific unconditional rather? Section 61(5) of the Act it means no condition which prevents property from passing, and deliverable state is delivered as a condition where the buyer is meant to take delivery. So in the case of Underwood and Burke Castle, an engine that was fixed to the premises of the vendor was not in a deliverable state at the time of the contract because it had to be unscrewed. The sale of a loose chattel was what the envisaged. So the engine has to be dismantled. So something has to be done to put it in a deliverable state. So here, the software has not been uploaded. So that means that's not in the deliverable state. And rule 1 does not apply. Rule 2 applies. So property will not pass until that thing has been done. We would need to establish if the software was uploaded in this case, and if it was uploaded to the computer before the fire, and whether, so remember I said when I was talking about this, is a two-pronged test. The first thing is, has the software been uploaded? Does Claire have notice of this? And it's a conjunctive demand. We need it to both tests to be complied with. So unless both apply, then we can say that she will be entitled to sue for non-delivery because that software has not been uploaded, property has not passed, she doesn't bear the risk because property has not passed. But we can see, the Act says that unless there's a contrary intention, that's not evidence in the contract. So we don't, she will be able to sue for non-delivery. And if the contract is entered into after 2015, she will not be able to then, Claire will not be able to argue that she's a customer because she purchased this computer for using her business, section 2. To be a consumer, it would have to be purchased for purposes wholly or mainly outside her trade or profession. So in non-consumer contract, unless a contrary intention is apparent, by virtue of section 21, property and risk go together, and it looks like property has not passed here, so risk will still be with SIA rather. But This is an agreement for the sale of specific goods pursuant to Section 7, where the goods perish post contract but prior to risk passing to the buyer. So the contract is avoided. There was an arson attack and all goods were destroyed. So they will have perished. So that means it was after the contract was concluded. That was when, not really, you said unascertained goods, the entire bulk is destroyed. You might want to expand on that, Hong. You might want to expand on that. So this is an agreement for specific goods pursuant to Section 7 because it is an display. Let's look at, yeah, X demonstration computer, which to buy their X. So it is specific, but at the end of the day, it was destroyed after the contract. So this is what a top end answer would do. That answer will consider the relevance of Section 7. So in the case of ASFAR, let's spell that ASFAR, and Blondell. Now I have to be sure to finish before the contract will be avoided, provided the risk has not passed, and if arson is not the fault of the seller. In the Law Reform Frustrated Contracts Act does not apply in this situation because Claire has paid for the goods but received nothing. She will be able to recover our price on the basis of total failure of consideration. So that's how she's able to avoid the contract. She can get her money back. So moving on to talk about Dan, I think that's the final one. He's setting up his business with his neighbor and wants to buy those computers. So Dan has agreed to buy 3 of the 4 computers in stock, and this means that the shop should supply any 3 of those 4 computers. And here we go to what we talked about in relation to possession of a power of a bulk. So she has 3 of the 4 computers. So that means he has 75% undivided shares in common with Sia. So Section 20A applies because the bulk is specified and Dan has paid for the goods. That section is silent on when risk passes, and it has been suggested by Scruton LJ in Stearns and Vickers that the transfer of an undivided share in goods should also carry transferring risk. But it is generally thought that since 20A is silent on the matter, property will pass under Section 20 only when property does under 18 Rule 5. But we see here that there is nothing left to be done to the goods to put them in a deliverable state, and it is an unconditional contract. The goods will pass when they are ascertained, and the goods can be ascertained to the contract through exhaustion. So if he has taken one out of it, that means the rest will belong to the company. I'm trying to see if I could finish that now, but I've seen that lots of questions have come in here. Is this a contract? It is avoided because in answering the question about whether it's avoidable is voidable, whether it's void or avoided, it is void when that thing is destroyed before the contract comes to an end, before the contract is entered into. So Katuri versus Hasi, at the time they were entering into the contract, that thing no longer exists. So Section 6 is relevant if it's destroyed before the contract. Section 7 applies if its specific goods is destroyed after the contract. So I hope that clarifies the distinction between the two. Kane, is this contract, in this case, it was destroyed after the contract was entered into. So to be able to avoid the contract, she needs to give notice because this doesn't fall under one of the exceptions. We can revisit it on Monday. I can restart from. Okay. Yeah. Okay. I think it seems like you get it. Yeah. So let's see the other comments. Yeah, I think I've answered that question. So you're saying not really uncertain goods, the entire bulk is destroyed. Yes, it's uncertain, but what about what we said, an identified portion of a specified bulk hung? It says here, um, was in the process of, he had agreed to buy three of the four. So there's a specified bulk. So is that analogy we created will be relevant? So the answer to the question D, no, we've not finished talking about question D. We're still talking. We've finished talking about question C. That's one we said is it can be avoided. We're still discussing question question D. Do you get my point? Do you understand? We've not talked about question D. That's the one I started with, but I just think it's the end of the time our time for today, and I don't want to hold you for longer than necessary. But do you need further clarification, Wong, before we close for today on question C? Remember, it's a specific good. Okay, great. So you understand. So that one it could be avoided. As always said, applying rule two, the property in good will not pass until that has been done and it's been uploaded. And we said she will not be able to argue that because she purchased it basically, mainly for use as a consumer because it's wholly for a purpose outside of as a non-consumer contract is wholly mainly outside of our trade, but that's not the case here. So in non-consumer contract, section 21 applies, and we're saying it's an agreement for specific goods pursuant to section 7. So there was an arson attack and all was destroyed. So the contract will be avoided provided risk has not passed and the arson is not their fault. So the Law Reform Act does not apply in such situations, those other ones. So in this case, Claire has paid for the goods but received nothing, so she will be able to recover her purchase price on the basis of total failure of consideration. You might want to have a look at the authority, the Fibrosa, Fibrosa, and we'll come back to discuss that before moving on to D on Monday. So if you have you got any other questions? I know I've taken more three minutes. I feel bad about that. But if you've got no questions, you're free to leave for today. See you on Monday when we answer the second question, and then we address the final topic, which is exemption clauses. You also will be looking at a student essay written by students, and we'll discuss the mark given to the students. All right. Yeah. So, or yeah, you're free to all leave. Um, I'll stop recording now and I'll stop sharing first and stop.